a day only.
My lord.
We can consider that. Subject to you're doing it tomorrow, day after, preferably day after.
No, day after tomorrow.
Hello, bless.
Good. What? We'll take up those matters where there are no records at this moment first, then we'll go for the other matters.
Lordship, in this case, Lordship, I need some more time, Lordship, because there is some anomaly going on, Lordship. So I'm waiting for proper instruction, Lordship.
You have the records.
Yes, yes, Lordship.
Why you need more time?
Lordship, they have sent a letter to ERO, Lordship. As per telephonic instruction, Lordship, the person whose name reflected in the LVS report as well as ERO's report, Lordship, both of them are two different persons.
What is the stand of the petitioner in his written statement?
Written statement, he is the son of Lordship, those person whose name reflected in the ERO's report, Lordship.
No, that's what we also did he object in his written statement that he is not the person to whom the notice was sent?
No, no,
In
that
that case, what
no.
further time you need? Is it a case of the petitioner that he is not the person or is not the son of such and such person
No,
to whom the notice has been
that
issued?
plea was not taken in the WS, Lordship.
Hmm?
That plea was not
If
taken in
that
the
view was
WS.
not taken in the written statement, now he can open it up or what? What is the stand in the written statement? It is annexed.
Yes, yes, Lordship. Yes, that plea was not taken, Lordship.
Was the record? Okay, we'll take it after some time. We'll come back.
Yes.
We'll take it up.
No, please, Your Lordship. Lordship, in this matter, we have to file our reply, Your Lordship. So we need some more time. Ah.
List after 3 weeks on the prayer of Land Council. Mr. I. Chakma,
SK Chakma,
Sorry.
Your Lordship.
S.K. Chakma. Enabling the petitioner. File. Or reply, or affidavit. An affidavit in reply. Affidavit and affidavit.
I am deeply obliged.
Was supposed to get
Yes,
instructions.
Mr.
Yes, Lordship,
Anything, any
Lordship,
positive?
positive Lordship, in fact, once 1 year back, it was sent and the Myanmar government Lordship, they said that he is not a citizen of Myanmar. They could not find his household. Again, a request has been sent, Lordship, in February, Lordship, that is awaited, but once it has been confirmed that he is not a resident of that country.
This was in February. And no
Lord-
reply from the,
February, Lordship, that reply has not come, but last year's they have
no,
given.
last year's reply is there.
Yes,
Hmm.
February it has not come, Lordship. That is awaited.
Thereafter, whether the external affairs have taken any steps with the Myanmar
Lordship,
embassy or not.
uh, Lordship of, this is a communication issued on 1st March, Lordship.
Hmm.
It does not appear that after February 26, 24. I mean, because this is a recent one. This is a reminder sent on February 26.
Yes, Myanmar government, they don't want him.
UOI means what?
Bureau of Immigration, Lordship.
And BM means?
Bangladesh, Myanmar.
I'm from Bangladesh.
I don't know, at least not from Myanmar.
No, probably there are two divisions together, Bangladesh and Myanmar division.
Yes,
Maybe.
So maybe the external affairs having such divisions,
that is one
Maybe.
division.
Maybe.
Bangladesh, Myanmar is one division.
maybe it's a one division.
do we do? What do we do? Huh?
Maybe.
Get a response for this, maybe we'll know better.
Huh?
They would don't want to accept, lah. One is just very clear. But then where will he go?
Maybe in the detention company because the
For
project
life.
is not proper.
But what about his liberty?
That's another judgment, division bench judgment, which says they can be given.
Mr. Chaudhary, do you have an extra copy?
I have one.
Give it to ma'am.
I'm giving them up.
Ma'am, in the next letter of 1st March 2024, if you have it in your hand. Please come to para 5.
Yes, Lordship.
Kindly read it. There is some response.
By the email dated this, MA requested the political B department of Assam to again provide the duly filled in PDF with the complete address of Muhammad Yasim Arafat MEA, received the PDF from the political department on March 6, 2023 and forwarded it to the MOE for nationality verification. Response from the EO External Affairs is still awaited.
Embassy of Myanmar. EOL.
It's embassy of
Myanmar.
a reminder has been sent on February 26, 2024. So I guess we'll have to wait.
We have to wait.
We'll have to wait.
Okay.
Let us come after Bihu, Lordship. It's no
We'll have
point.
it sometimes in May,
Yes, Lordship, that's better.
during election process and.
And
but anyway,
nothing
we're
will
giving
happen.
Some more time. We'll have
Yes.
it in later part of May.
Yes, Lordship.
Order Mr. Hazarikal and its senior counsel, assisted by Mr. Khan, right? Yes, Lord. Counsel for the petitioner. And Mr. R.K. Dev Chaudhary, learned Deputy SCI for the respondents and the union media. Mr. Dev Chaudhary, learned Deputy SCI. By placing the relevant communications of the Government of India, Ministry of Home Affairs, Foreigners Division, dated 11/03/2024, as well as the Office Memorandum of the Ministry of External Affairs, Bangladesh and Myanmar Division, dated 1st March 2024, submitted that after receiving the duly filled PDF pertaining to complete address of the detainee Muhammad Yasin Arafat, the political. No, don't write. It was forwarded to the Embassy of Myanmar. During March, April 2023,
Any idea what we'll do? Are you taking time? Because you're not responding.
regarding the nationality verification, regarding his nationality verification. And that response from, I go to the Embassy of Myanmar, like it's a capital E, small o, and bracket on. From said is awaited, and further reminder was issued to the on last 26/02/2024. The respondents in the Ministry of Home Affairs Foreigners Division submitted that the response from the is awaited. Mr. Next. Dev Chaudhary, learned Deputy SGI. On instruction of the respondents in the Ministry of Home Affairs Foreigners Division, also submitted that earlier in the year 2023, no, earlier in 2022, when the issue of the petitioner of the detainee involved in this case was taken up with the authorities in the Myanmar, on 09/01/2023, the EOM conveyed that the name of the detainee involved in this case hasn't been included in the name list of household population census of Myanmar. Since the Ministry of External Affairs, BM Division have already issued a reminder to EOM on 26/02/2024, as noted above. Place this matter again on 38th of May.
Yes, Lord.
38th of May. Enabling both the Ministry of Home Affairs Foreigners Division as well as the Ministry of External Affairs BM Division to apprise the court about the up-to-date status regarding the status of the illegal migrant, i.e. the detainee concerned involved in this case, who claims to be a citizen from Myanmar.
Blessed.
Copy of the communication dated 11/03/2024 of the Ministry of Home Affairs Foreigners Division, as well as the communication dated 01/03/2024 of the Ministry of External Affairs BM Division, placed by Mr. R.K. Dev Chaudhary, Deputy SGI, be kept as a part of the record. No, one problem.
Well,
No, one will. We'll have one.
Well,
We'll take two after some time. We'll finish the item number 1. Give us the record. Take your seat, Mr. Sharma. Let us go through the record first.
There is no reference. Reference it will be true that none may be caught. The my one to make a play.
Where is Mr. Cooley? Ask him to, ask Mr. Ali to be here.
Ali is out of. Ali is out of state.
Application করে লিখে কেন China school Lamb Kota mana namanya sih
Now come to page number 3. Mark 1, 2, 3. I think 1 is the last.
Komando
Two is the second.
Lamb pana
And the third is.
Lamb pana
Give me some time, I will verify.
Third. So you have to do 1, 2 and 3.
Bamun,
Bangun
Lempara,
Lamb pana
Bamun.
bangun
One and two same place, but
1 and 2 same.
Bamundanga part 2.
2, 1.
One and
What
3.
is the next one?
One Lemapara,
What is the name of the person?
Hossein Ali,
Who is there?
Lempara,
And down below, what is the name of this father? Date.
late Khalil Sheikh.
Come to page number 2. That is the report of the LBO. Mark page number 2. What is the year, let's say? Name of the proceeding.
Hussein Ali,
Which village?
Bamundanga, Part 2.
Previous page, the ERO says, the LBO says on Ali from Lampara,
Hmm.
right?
Right.
The ERO says the man from the Pamundanga part.
Part 2.
What is the reference? What is number page?
Bamundanga, Part 3. 2.
Pamundanga part.
Yes,
What
ma'am.
is the full?
Hmm. Give me some time, I will write.
What do you do? What do you ask the patient?
I will ask my senior.
What do you ask? That's what you want to know. What do you ask? The LBO found a partition in the village Lampara to be a doubtful subdivision. And he accordingly informed area,
Yes.
but the ERO instead of the person from village Lampara have noted a person of similar name, whose name of father is different from the village Pamundanga, both under the same LSC. This Corpora LSC.
Hmm.
Now, considering the report of the year, depending on the general Corpora, refer the matter to the trial. With regard to the person from Pamundanga, not from
Lampara.
them. Considering that the tribunal, after registering a case, it should notice to the person from Pamundanga. And the tribunal, after the all the matters of the hearing evidence, found the man from Pamundanga to be a foreigner. Now, right here or wrongly, there was a reference from the Superior Police Court Guadalajara, which is to be presented. But the review report initially was against the person from them.
Hmm.
Right? Because the PRO letter, the name of the petitioner against father is there.
Yeah.
Similarly, the reference also comes with the name of the petitioner against father.
Hmm.
And accordingly, the tribunal issues the notice to the petitioner. The petitioner failed to prove under section 9 of the Ordinance Act to the tribunal that he is guilty. Against which, there is reason. Now, what will happen? Although the LBO did not mention this name, but the ERO and the reference was against it. It will happen. It will happen. There will be a report from the LBO against the petition.
Yes.
Who is from government,
Bamundanga.
but this file consists of a report of LBO.
Lampara.
With regard to a person who is from them. You have to tell us whether the ERO on the basis of the report of the LBO. But there are two parts. Clearly, LBO gives its report in Annexure A. And the ERO gives its report in Annexure B. Annexure A of the petitioner may not be available in this. And Annexure B, that is the PRO's report of a person from Lempara may be in another report. Good to know. Only while providing, the PRO will not commit this mistake, particular mistake, because there are the same possibility. Create a difference.
Yes.
Where you see it? You see your past. They were there.
Iya, itu patra. Totally ada betul itu. Oh, pikiran tidak.
There is one. There is a name of
Pandubai district.
two part, other villages there.
Panduba,
There is a number of people.
191 Panduba.
Yeah.
Or 193 Lempara.
One night, yeah. Yeah.
Or 108 Pamundanga, দ্বিতীয় খণ্ড।78 Pope Pandanga School. 99 91 Panduba. 93 Lempara. Go 108 Pamundanga, Yomonda. 191 Panduba. Two two three Panduba. Panduba. গোয়ালপাড়ার পূর্ব
I don't know. That is not a valid reference. Sir. Let us wait and see.
Waiting for the answer.
Annexure B,
Give us the name.
name Pamundanga Part Two, Hussein Ali, son of Asadullah Sheikh. Pamundanga Part Two,
Is under the scrutiny,
LBO report Karegor, no,
signature নাই।
I will ask my son.
Make a dictation. Certificate কি হলো? ভাঙি কিয় নিদিব? এপ্লাই কৰিলে দিব। ফটোৰ পৰা যিকোনো ৰেকৰ্ডৰ পৰা যিকোনো ডকুমেণ্টছ চাৰ্টিফিকেট কৰি ল'ব পাৰে। চাৰ্টিফিকেট কৰি ল'ব পাৰে। LBO report, SP report, কালেক্ট কৰি আমি এৰেঞ্জ কৰি এডিশনাল এভিডেন্ট ৰিডিং আপ থাকিল আৰ্গুমেন্ট কৰিছো ৰিটাৰ্ণ কৰিছো এইটো ইট ইজ নট পাৰ্ট অফ
Secretary.
Commissioner,
Election commission.
CP. আমরা দেখলে পয়েন্ট নিতে প্রোগ্রাম করে দেবো বাইরে থাকো হুম হুম আমরা এটা রেখে ঠিক আছে তুমি ডকুমেন্ট সার্টিফিকেট করুন অ্যাপ্লিকেশন করো দেয় না দেয় তার এসপি রেফারেন্স ইয়ার নো
Election commission.
ইয়ার আন্ডার দেবে এটি একটু বেলে অ্যাডমিনিস্ট্রেটিভ লিগ্যাল পয়েন্টে গেল ইনভেস্টিগেশন করে না না করে হুম তো ঠিক আছে করুন collective retail meeting আনতে কারণ এটা তো আলাদা টেন্স আমরা এখন পকেটের পয়সা গায়ের পরিশ্রম দিয়ে হইলো একটু একটু কাউন্টার নাহলে আমরা একটু ঐতিহাসিকভাবে এই জন্য আমরা করতাম, এই জন্য করতেছি আমি। নাহলে কি কেসই করো না, কেস করে আমাকে ক্যারিয়ার নষ্ট হয়েছে একই কাছে। Report, ERO report to based on LBO report. LBO report to মানে পুরাবো বিচারা, কিন্তু ERO report to পুরাবো নি বিচারা, একটু সিগনেচার নাই ডকুমেন্ট on what basis that has been. ইলেকশন দিলে ভালো হতো। ইলেকশন তো আমাকে সাথ নেই। চেঞ্জ করা যাবে না। হুম, আপনার 7 নেন জন। হ্যাঁ, আপনারা দিব, আপনারা কপি আছে, একটু ফটোকপি বানিয়ে দেবো। বানাই দিবা। হ্যাঁ, ইউটিউবের কথা। April 25 তারিখ হবো তাই। আমার ক্যাম্পেইনে গেল সানডে স্যাটারডে ডিপ বিপ্লব
My lord. Extra copy can you provide me?
Do you have an extra copy of the video? I don't have. Even. Nalage. Huh?
Very solid.
Report to sign up. No, this is a repetition copy too. Lordship, maybe have a look at the records, Lordship. We would like to look into the records. Sorry. Yes, Lordship. Lordship, actually, we do not have the petition copy, so we were just seeking for one.
Yes, Lord. Regarding? Yes, yes. Yes. Yes, Lord. Hmm. Yes. Cannot. Yes. Yes, yes, Lord. Yes, yes.
Fresh
Yes,
notice.
yes,
Yes.
yes, Lord.
I have the notifications with me. We had earlier given it in one of the matters. I am giving notification and Sarbananda two clarifies that all matters to be renumbered and shifted to the tribunals. Yes.
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 Yes. Yes.
And here the matter. Yes,
Mm.
Lord.
Yes.
No, Lord.
No. No, no.
It has to come to its logical conclusion.
WPC 2674/16, Monwara Khatun. What is falling from Lordship is? I will just read out that part.
Seven. All right.
Adverting
2674.
2674 of 2016. Therefore, irrespective of whether the suspected person was found to be an Indian national or not, reference used to be made to the tribunal. As a matter of fact, the EC of India also issued notification on 10/1/98 instructing all doubtful cases received from electoral registration officers were required to be referred to the Foreigners Tribunal. No other authority other than the Foreigners Tribunal could decide the cases. It is in such circumstances that the reference came to be made notwithstanding the report of the inquiry officer. The affidavit has referred to the full bench decision of this court in State versus Muslim Mandal, wherein it has been stated that reference made by the referral authority cannot be mechanical. The referral authority has to apply his mind to the materials collected by the investigating officer and thereafter make a reference. Insofar as the case of the petition is concerned, it is stated that the so and so after proper application of mind on the report of the inquiry officer came to the conclusion that the petitioner did not appear to be a foreigner. Same case here. In the light of the above position, we felt the tribunal ought to have returned the reference back to the referral authority. A notice issued by the tribunal was apparently contrary to the reference made. Though this court has clarified that if the tribunal finds a reference to be contrary to the materials on record or finds the reference to be faulty, it should remand back the matter to the referral authority for meaning of first reference. But in the instance case, we find from the affidavit of the DGP that the report of the inquiry officer as well as the endorsement were made after proper application of mind. In such circumstances, without entering them into the merits, we feel that the impugned order passed with the tribunal cannot be sustained and is accordingly set aside. Justice Ujjwal here and Justice Silo Mehta, as they were done. Then we had another in 2017. Division bench. WPC 7551 of 16. Another one is 7551 of 16. The first one is 2674 of 16. The second one is 7551 of 16. Without a reference being made, tribunal cannot exercise jurisdiction to opine that a person is or is not a foreigner. Tribunal would have to confine to the terms of the reference. The reference was that I'm a Indian citizen. Therefore, that is now, once it was dropped, without an application, without anything done from the referral authority, it was simply restored to fine. Had there been a second reference, of course, this man would have gone and tried to prove his citizenship. Can this case be reopened is the issue that, with which I stand before you. If there is a first reference, there is no difficulty. No, no, below the point.
1065/18. My lord, so 7551 of 16. 16, Santosh Das. One is Santosh Das, one is Monora Khatun. And Lordship, another case is Lordship yes, Lord. Recently decided Lordship Aziz Mia case Lordship 2370/2023. WBC 2370/2023. Decided on 9/6/2023.
Number to go.
Hmm?
27, 26,
2370
2370 of
2023. Monora Khatun's case also referred in this case, Lordship. Just thoroughly discussed, Lordship. Yambujoglu. Justice Yambujoglu.
Aziz Miani,
Aziz Mia।
কি করে দেখুন?
তাতে আপনার রিপোর্ট মানে রিপোর্ট
No, that is good.
আরো
Yeah, it could be. Yeah, you get paid for the
From-
proceeding to be done. No, no. Whether the proceeding to be dropped or not was the issue.
Hmm?
Whether the proceeding to be dropped or not was the issue. Only if it was after being dropped, can you reopen? In each case, what is the procedure? Maybe that's the procedure.
রাজেশদার কেস মানে maybe eight years. মানে ভেরি করার প্রশ্ন
Finally, properly. Report properly. It would record.
Santosh Das, my lord, unless there is a reference, there can be no second proceeding. My lord. He can only, but what I was trying to emphasize is, if there is one, then my lord, they can proceed. There is no question on that, no quarrel on that. I'm not quarreling. What I'm trying to say is that once a proceeding is dropped for whatever reasons, would the tribunal still have the power to suo motu, just reopen it? If it can be done for while trying to declare a person to be a citizen, then my lord, a person who was declared to be a foreigner, that can also be reopened then. But once the true. So therefore, my lord, if it could not have dropped, the only option was to refer it back. The issuance of notice to me at that stage would not have arisen, cannot have arisen. That is the only issue. If that is why, my lord, time and again I am saying, even when I was discussing it with my senior friend here, my lord, what I was trying to say is one more reference. This man faces the trial. Well, that is the law that we will face. We have enough documents to show. I am not shying from that. Yes, please. Any document to show.
Take one judgment of 1065/2018 WBC, Safia Begum. Here, D voter issue was there. And after discussing all things, one of the court said that upon receipt of the reference, it has to be registered. And at the same time, uh, as we have discussed in the earlier round, the members used to keep the matter as filed. The order was written like that, it is filed. That means it was closed or dropped, something like that. Some order came from the court, my lord, said that that cannot be done, it has to be reopened. The judgment, if you.
Members.
Tribunal, tribunal.
And on that, my lord, then the judgment, if permits, I will propose for this tomorrow. Ananda. Yes. Yes, that was Ananda, Ram, something like that.
In that case, my lord, the reference,
And that was a case, my lord, where he.
আপনি এত যদি check করো। হুম? তো ভালো এখন।
Aziz Mia.
Aziz Mia, pela pergunta, la pergunta que me coloca. Suspected person did not appear to be a crime. Mukesh stood that it did not appear to be a crime. Okay. The poet arrived at such a conclusion and no file was given to report of the case. In the instances, he was declared to be a crime. It was the suspected to be a crime.
Anandaram, something like that. That was 55 of 2010, I think, that review petition. That was review number. The earlier read petition was something. Where it is discussed that he repeatedly used to not prefer to not to 10 or something like that. Anandaram.
No sense. Language. Que no for review সাধারণত লেগেছে 2010
Ravi Das or something like this.
review নাই
Anand Ravi Das or something like that.
the reference to reference aspect. এখন প্ৰথম উপায় এনকাৰী কৰোঁতে সেইবিলাক মোৰ কাৰণে এইবিলাক মই দিলোঁ এতিয়া পিছফালে আৰু আচলতে এনকাৰী এইটো হ'ল আপুনি তাত এইটো কৰি according to the documents submitted by council, Azharul Mia may be an Indian. It's an inquiry officer report. No, inquiry officer report. It will put a formal from okay. Formal communication has been like a formal particulars information collected from the suspected. The information to the benefit is collected for him. This is by himself. Final report of suspected. I will very then there is a reference. This particular reference of order of the deputy commissioner. It will connect with agree with the opinion. Honorable. What's your opinion?
Lordship, it is, yes. 22, yes, 20. Yes. Maybe. I got. Well, yes. I'm sorry that. Repetition number 3449 of 2019. Their review was, yeah, the observation was. Repeatedly appear করা নাছিল
Even review
Absolutely.
Yes. Hmm. Well, yes. Yes. Para 96, my lord. One of the contentions of the proceeding is that though the referral authority is required to make the reference to the tribunal after making a fair investigation, no such proper and fair investigation is conducted, and the police at their own whims and caprice gives a report. In some cases, even without visiting the place where such proceeding resides and also without giving any opportunity to produce the relevant documents to substantiate the proceeding is not a foreigner. And such report is accepted by the referral authority, and accordingly, the reference is made to the tribunal on the basis of which the reference is registered against such person. For 97, fair investigation and fair trial being the basic fundamental and human right of a person who is co-committed to preservation of fundamental right of a person under Article 21 of the Constitution, there has to be fair and proper investigation by the investigation agency before making a reference to the tribunal. In such investigation, the attempt has been to be made to find out the person against whom the investigation is made, so that the person concerned is given the opportunity to demonstrate at that stage itself that he is not a foreigner. In case the person concerned could not be found out in the village where he is reported to reside, or in the place where he ordinarily resides, or work for gain, the investigating agency has to record the same in presence of the village elder or the village headman or any respectable person of the locality, which in turn would ensure visit of the investigating officer to the place where such person ordinarily resides or reported to resides or works for gain, and making of an effort to find him out for the purpose of giving him the opportunity to produce the documents, etc., if any, to demonstrate that he is not a foreigner. The investigating officer, as far as practicable, shall also obtain the signature or thumb impression of the person against whom such investigation is initiated after recording his statement, if any, provided he makes himself available for the purpose. There are also instances where the person against whom such investigation is initiated changes his place of residence, maybe in search of his livelihood, or maybe to avoid detection. To ensure proper investigation also, and also having regard to the integrity and sovereignty of the nation, once investigation relating to the nationality status of a person starts, he must inform the investigating agency in writing about the change of residence, if any, thereafter. The case, in case such person has failed to intimate the investigating agency in writing the subsequent change of his place of residence, the investigating agency has to mention the same in the report, in his report, with his opinion relating to the status of such person on the basis of materials collected at the place where he earlier resided. That will ensure a fair investigation and submission of proper report on such investigation to the authority. Needless to say, such investigation need not be detailed or exhaustive, or keeping in view the nature of the proceeding before the tribunal and the object sought to be assessed. Hence, it need not be equaled with the investigation conducted in a criminal case. The reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the material collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order or order recording his satisfaction. An order agreeing with the investigation would suffice. The referral authority also, while making the reference, shall produce all the materials collecting during the investigation before the tribunal, as the tribunal is required prima facie to satisfy itself of the existence of the main grounds before issuing the notice to the proceeding. Fair trial and reasonable opportunity required to be afforded to a proceeding also includes supply of the certified copy of the public documents, including the copy of the relevant electoral rules, which has also been recognized by subsection 2 of the section 6A of the 1955 Act as relevant document for the purpose of establishment of the citizenship to the proceeding whenever asked for, which may be necessary for the purpose of demonstrating by the proceeding that he is not a foreigner. Certified copies of such documents, if applied for, must be supplied promptly. Otherwise, it may result in delay in disposal of the reference proceeding, as the proceeding in that case may ask for time till such documents are made available to him. The same may also amount to denial of reasonable opportunity to the proceeding, as he may not be able to discharge his burden of proof that he is an Indian national. In the absence of such documents, such delay in disposal of the proceeding would also be against national interest. The interest of justice therefore requires supply of certified copies of such documents that to promptly whenever asked for. Question E. What would be the appropriate procedure relating to the service of notice on the person against whom the reference proceeding has been initiated? That is my lord. Yes, ma'am. Yes. The record, ma'am. Documents. Yes, ma'am.
It is there in this. No. No, before the police also at page 33, I have submitted the voter ID and everything of my father. Yes. First, the final interrogation from Lordship will have. I have given documents then also. Not now.
ফাইল করা ক্ষেত্রে আমাদের
Can you please explain?
Mhm. And temperate. Indian. Famous person. Okay, PhD. Mm. Mm. Yeah, you should notice. First of all, my lord, the- or he will have to give an opinion. Or he will have to give an opinion, my lord. The references issue notice, then my lord, finally he has to give an opinion. What my submission is that, my lord, what is there in the investigation is a different, that is a different issue. And what, yes. Yes, ma'am. Is it- Correct. So is a foreigner or is not a foreigner? Either or both. Yes, ma'am. State government. Is not foreign. 1946. Or not a friend. Person. One of the six. That's to drop. That is the point, my lord. Whether it become functus officio. Only. Tribunal remain the same. My lord. My lord, what just before me, my learned senior friend has informed this court that there was a case. Yes, there was a case, my lord, where this honorable court directed. Probably the judgment is not there, which me now, my lord. No, one judgment is there, my lord. But, my lord, I forget the name. No, that is, my lord, with regard to filing of cases. There were thousands of cases, lakhs of cases, which were filed by the tribunals in their office, my lord, without issuing any notice. Then this honorable court directed, no, you cannot keep cases being filed in your tribunals. So all these cases have to reopen. There was a direction from this honorable. No.
Yes, my lord. Yes, my lord, that was there. But
There was a
that,
case.
that is
I-
also the division bench judgment.
Division bench of this, yes,
Yes.
division bench judgment. In fact, I was there, my lord. I forget the case number. Yes,
Yes.
are filed.
Yes, fine. Yes.
Yes, yes. Reopen.
Means that without expressing any opinion,
Opinion.
the tribunal cannot keep the matter as filed.
Because here there is no opinion. The 20, probably 2018, 18, 19. 18. Yes, 17, 18. 18. probably.
17, 18. Sorry,
Yes, 17, 18, in between.
If Lordship give us one day time, I may.
I can get it, madam. No.
It is with me, but not right now. Yes, it is with me. Yes, yes.
We can get it, my lord. In fact, I also remembered the case, but I have.
Okay. That is with me.
Yes,
Yes.
yes, ma'am. I'll get it. May I just point out one thing, my lord? One of my grounds here is that even while referring the matter, my lord, there was no opinion given whether I had to say whether I was from the post 1966 or 17 era. That was never opined anywhere. And lordship has written in the, my lord. I forget it. Done. So, my lord, what I'm trying to say is, my lord, if lordship will have how the inquiry officer has to refer it, my lord, when these things will fall into place when the authority who's required it to do, who is required to do something, does it properly. Otherwise, this will remain. These, no, since what I'm trying to say is, my lord, when the form itself and when it has fallen from lordships in the order, that the opinion is that yes. Yes. What I'm trying to point out, my lord, what I'm trying to point out is what has fallen from lordship in this order is that the reference said that an opinion was to be given of which period. What I'm trying to say is that he never said which period. That would be a misnomer in the order is what I'm trying to point out, my lord. Yes. Prima facie manner, it appears to me that national. Now, lordship will
Lordship will only look at the,
Hence, the case may be forwarded to the honorable member
Yes.
to be further studied on what kind of.
if that is reflected in the order, my lord, I have no difficulty, I would not have any. What I am just trying to say is, my lord, Lordship has said that it will be for a particular period it was being referred to. It is not. It was not referred for a particular period, is only what I am trying to point out, my lord. Just keeping it. And the second part, my lord, I had given documents as my father being Amir Uddin Mia, not Amir Mia. That part, my lord, would be. Yes. The Lordship will find at page 37, Lordship will kindly find. The extract copy of voter list of 1966, where his father's name is appeared as Amiruddin Mia. So that is what I place before the inquiry officer. That is what will only be taken on. Amiruddin Mia is what. I'm not trying to find out fault with the other things. I'm just trying to point out that what is there on the record should be reflected. Only that much, madam. I'm obliged. Madam.
Citizenship, there is. Yes. Decision tribunal may opine. Yes, my lord, this entry comes from the IMDT. That is the issue. Yes, madam. Foreigner's sake. These two forms are not necessary. Yes, madam. Find out. My lord, what my submission is there, my lord, the two forms, which my learned friend is preparing, two forms. In fact, these two forms are not necessary at all. This has come from the IMDT only, and that is following till date, my lord.
Yes.
Yes. Whether he's a foreigner or not, yes. Which history? 47. Yes, that has to be given by the opinion, in the opinion only.
Obliged.
Lordship, after review.
Do one thing. You read the judgment in the grounds that is there in the review petition. And reply be made by the other side. Regarding your arguments, you submit your written argument. Because this is review. To submit your written arguments. We'll see to that. Okay. So start with the judgment passed by the coordinate bench along with my brother earlier. Then the grounds of the review. Because these bans will not be available again. That is why these matters have been listed during this period. Will not pass any adverse order in absence of your senior, but you give your written argument by Friday positively, right? Okay. You have the brief with you? Page 20, where is the judgment?
It is admin order.
Page 21 is the judgment.
Yes, Lordship.
It starts at page 20.
Yes, Lordship.
Okay. First tell us when you have filed this review petition.
25th January, no? 25th January, Lordship.
25th January of
2022.
2022, when the order was passed.
It was done. 24th January. I don't know.
So after 4 years,
Oh, yes.
right?
Yes, Lordship.
Now, did you prepare any SLP or anything after the order of the tribunal, after the order of the coordinate bench?
SLP Chicago working. SLP. No, Lordship.
You have not prepared.
No, Lordship.
Then why you have prepared this review petition after 4 years? Have you explained the delay in any paragraph in your review petition?
No idea. Lordship, I am not prepared about the case.
You are not aware. Doesn't matter. You will just read. You have the review petition in your hand.
Yes, Lordship.
Come to page number 17 and read para 16.
Para 16. That the review petitioner submits that the aforesaid judgment and order in the instant writ petition was passed on 24th January 2018, and the petitioner has approached before this honorable court now after expiry of almost 4 months.
4 months or 4 years?
4 years, Lordship.
It should be 4 years. You note it down. It should be 4 years, not 4 months. And then
Therefore, there is a delay in approaching this honorable court, but the said delay is not an intentional one, rather due to the fact that the aforesaid time was expanded for collecting the requisite fees. Therefore, the petitioner prayed before this honorable court to condone the aforesaid delay and admit this petition for the ends of justice.
okay. Now please come to the grounds that we have stated in the petition. At page 13 onwards up to page 17. So kindly read the grounds for review.
Yes, Lordship. First para, for that, this honorable court in the order dated 24 January 2018 passed in the connected writ petition viewed that the writ court would not interfere with the findings of facts unless it is a case of violation of the principle of natural justice or non-conformity with the procedure prescribed under the Foreigners Tribunal Order 1964, or if it is a case of admissible evidence being not taken into consideration, or if the finding recorded by the tribunal is based on no evidence at all. In spite of such observation, this honorable court in the order dated 24 January 2018 did not appreciate the plea of the petitioner that the whole proceeding was initiated by violating the provision of the Foreigners Tribunal Order 1964. And the guideline framed by this honorable court is Muslim Mondal case regarding inquiry, accepting inquiry report by the concerned SP. For that, the view of this honorable court as expressed through the order dated 24 January 2018 passed in the connected writ petition regarding the documents exhibited by the review petitioner, which this honorable court held to be not proved by the review petitioner in accordance with law, is also jeopardize the review petitioner. The said view is harsh towards the review petitioner as because most of the documents are land records and voter lists which are prepared by the government employees of respective department and not by any private person or by the review petitioner herself. The review petitioner, being a private person, cannot ensure the presence of those officials responsible for preparation of those documents to prove their authenticity. Only the court or tribunal can ensure their presence and can call for the records as per provision of section 30 of CPC if the court of the tribunal have any doubt on those documents, and such power is also available to the Foreigners Tribunal as reflected under Order 4 bracket B of the Foreigners Tribunal Order 1964, that apart from the cross-examination of the review petitioner by the learned tribunal below, there was no such suggestion or doubting the authenticity of those documents only at the end of the trial. If the learned tribunal below at that time had any doubt on the authenticity on the documents exhibited by the review petitioner, either ought to have put suggestion in this effect during the cross of the review petitioner or call for the records by exercising the power conferred under section 30 of CPC, but none of those options had been adopted by the learned tribunal below. Rather, came to an conclusion which is irrational and violated the principle of natural justice. And this honorable court also holds the same view without appreciating the aforesaid facts which prejudice for the review petitioner. For that, this honorable court also in the order dated 24 January 2018 given negative emphasized on the variation of name of the father of the petitioner in the electoral roll of 1966 and 1970. But in doing so, this honorable court did not appreciate the facts in both the electoral roll, the house number and the age match with each order, which indicated that both the person are same and one. For that, this honorable court in the order dated 24 January 2018 hold a view that the review petitioner failed to prove her linkage with Kuduj Mia alias Abdul Kuduj alias Kuduj alias Kuduj Khatun by proving the certificate issued by the Kokila Gao Panchayat when this honorable court holding the said view did not appreciate the provision laid down under section dash of the Indian Evidence Act, which speaks that admitted facts need not be proved, and in the present case, the referral authority and or inquiry officer admitted the facts that Kudus Mia alias Abdul Kudus alias Kudus Khatun is the father of the review petitioner, which reveals from the reference itself. For that, this honorable court in the order dated 24 January 2018 passed in the connected writ petition discarded the affidavit submitted by the review petitioner, which she herself executed to solve ambiguity regarding variation of name of her father on the grounds that her father is still alive and he did not adduce the said certificate and had not turned down to depose his evidence in the learned tribunal below. This honorable court, while hold the said view, totally ignored the explanation given by the petitioner in this regard. For that, this honorable court, one hand, had a view that the petitioner was born on 1983, and it reveals from all aspects that she was born at village Kokila, Maulovipara, under Abhoyapur police station. If it is so, then the review petitioner is an Indian national by birth as per section 3(1)(a) of the Citizenship Act 1955. For that, the Honorable High Court did not consider the public documents exhibited in support of her nationality, nor believe the evidence of her brother, namely Ghulam Mustafa, SDW2, though their father's name are same. This clearly established the linkage of the petitioner with her father. For that, there was no rebuttal against the evidence of the petitioner as well as her brother on any vital point, and as such, in view of division bench judgment as reported in 2013, 1 GLT 941 para 9 and 10, those evidences should have been believed, and the petitioner should have been declared as not to be a foreigner.
So these are the grounds, right?
Yes, Lordship.
Now, please read the judgment at page 20, starts at page 20, but it basically starts at page 21.
Yes, Lordship.
Yes.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. A. Ahmed, learned counsel for the petitioner, and Mr. S.P. Chaudhary, learned government advocate, Assam. By filing this petition under Article 226 of the Constitution of India, petitioner seeks quashing of order dated 20/6/2016, passed by the Foreigners Tribunal number 8, Borpeta, in FT case number 159 of 2015, Union of India versus Kohinoor Nessa alias Kohinoor Begum, declaring her to be a foreigner within the meaning of Section 2A of the Foreigners Act 1946. It is seen that initially a reference was made by the Superintendent of Police, Border, Borpeta, under the Illegal Migrants Determination by Tribunals Act 1983, IMDT Act, suspecting the petitioner to be an illegal migrant. Be it stated that under Section 3(1)(c) of the IMDT Act, an illegal migrant was defined as a foreigner who had unauthorizedly entered into India after 25/3/1971. The reference was registered as IMDT case number 62 of 2003 before the tribunal constituted under the IMDT Act. While the reference was pending before the tribunal constituted under the IMDT Act, the said act was declared unconstitutional by the Supreme Court in Sarbananda Sonowal versus Union of India, reported in 2005, 5 SCC 665. The pending reference was thereafter transferred to the Foreigners Tribunal number 8, Borpeta, to be decided as per provisions of the Foreigners Act 1946, read with the Foreigners Tribunal's Order 1964, where It was registered as FT case number 159 of 2015. Notice issued by the tribunal was served upon the petitioner, whereafter petitioner had entered appearance before the tribunal and filed written statement denying the allegation that she was a foreigner by claiming to be a citizen of India by birth. Petitioner also adduced evidence. After hearing the matter, tribunal passed the order dated 26/2016, answering the reference in favor of the state in the above manner. Aggrieved present writ petition has been filed. This court by order dated 13/12/2016 had issued notice while requisitioning the case record and passed an interim order to the effect that petitioner should be allowed to remain on bail subject to her appearance before the Superintendent of Police Border, Borpeta, and furnishing of adequate surety. Learned counsel for the parties have made detailed submissions which have been duly considered. Also peruse the record, including the record requisition from the tribunal. On a careful analysis of the order passed by the tribunal, it is seen that tribunal had appreciated whatever evidence were tendered by the petitioner, whereafter a finding was recorded that petitioner was a foreigner. Such a finding is a finding of fact based on appreciation of evidence. Ordinarily, a writ court would not interfere with such a finding of fact, unless it is a case of violation of the principles of natural justice or non-conformity with the procedure prescribed under the Foreigners Tribunals Order 1964, or if it is a case of admissible evidence being not taken into consideration or inadmissible evidence being taken into consideration, or if the finding recorded by the tribunal is based on no evidence at all, in which event it would be a case of perversity, thus an error apparent on the face of the record. The other errors of fact, howsoever grave those may be, would not be corrected in a writ proceeding having regard to the fact that the jurisdiction exercised by the writ court under Article 226 of the Constitution of India is supervisory and not appellate. Notwithstanding the same, we have once again looked into the materials on record to satisfy ourselves about the correctness or otherwise of the finding returned by the tribunal. Record discloses that inquiry officer in his report dated 14/2/2003 had mentioned the address of the petitioner in the country of origin as village Nikrel under Tangel police station in the district of Mymensingh, Bangladesh. She had entered into India in an illegal manner after 25/3/1971 for food and shelter. Therefore, inquiry officer reported that it was prima facie found that the petitioner had illegally entered into India, Assam from Bangladesh after 25/3/1971. The report of the inquiry officer was approved by the higher authority, whereafter the reference was made by the Superintendent of Police Border, Borpeta, on 2/4/2003 under the IMDT Act. We have already noted transition of the reference from one under the IMDT Act to one under the Foreigners Act 1946. In her written statement, petitioner stated that she was born and brought up at village Kokila, Maulabipara, under Abhayapuri police station in the district of Bongaigaon. Abdul Quddus, alias Abdul Mia, was her father and Noor Khatun was her mother. Both of them were still alive and residing in the aforesaid address. Names of her parents were enlisted in the voters list of 2010, 1997, 1985, 1970, and 1966. After attaining the age of majority, petitioner married one Osman Goni, son of late Samed Ali of Hugubari village under Sorbhu police station in the district of Borpeta. Petitioner's name was recorded in the voters list of 2010 in respect of Jonia constituency. In the supporting affidavit sworn on 5/12/2015, petitioner disclosed her age as 32 years. If the petitioner was 32 years of age in 2015, it would mean that she was born sometime in the year 1983. 2015 minus 32 is equal to 1983. In her deposition as witness number 1, petitioner stated more or less the same thing. Additionally, she stated that she had studied up to primary level. 1. Ghulam Mustafa deposed as witness number 2 on behalf of the petitioner. He stated that he was the younger brother of the petitioner. Certain questions were put to him by the tribunal. He stated that he was working as teacher in the Osman Memorial High School. Though he claimed to be a voter, he failed to produce any voter list. He also submitted that he did not know anything about their land. Evidence of witness number 2, Ghulam Mustafa, would not be of much significance because neither in her written statement nor in her deposition, petitioner stated that she had a brother by the name of Ghulam Mustafa. That apart, though petitioner stated that her father, Abdul Quddus, and mother, Nur Khatun, were still alive, they did not come forward to depose in favor of the petitioner before the tribunal. This itself would dent the claim of the petitioner to a large extent. Proceeding to the exhibits, we find that though a number of documents were filed and marked as exhibits, in fact, from Exhibit A to Exhibit L, none of the documents were proved in accordance with law. It is tried that mere filing of documents before the court or tribunal or marking those documents as exhibits is not enough. Those documents would have to be proved in accordance with law to have any evidentiary value, which the petitioner failed to do. Petitioner is claiming her Indian citizenship through Abdul Quddus, whom she claimed to be her father, but in Exhibit F, voter list of 1966, the name which appears is Quddus, son of Akash Mia, aged 36 years, and in the voters list of 1970, the name which appears is Quddus Khatun, son of Akash Mia, aged 40 years. Even if we ignore the discrepancy in the name, whether it is Abdul Quddus or Quddus Khatun, what was required of the petitioner was to prove her linkage as daughter of Abdul Quddus. Exhibit A is a certificate dated 17/11/2015, issued by the President and Secretary of Kokilagaon Panchayat, District Bongaigaon, certifying that petitioner was the daughter of Abdul Quddus. The certificate would have no significance because the author of the certificate did not testify before the tribunal to not only prove the contents of the said certificate, but also the truthfulness thereof. In the absence of such deposition, no reliance can be placed on Exhibit A. That apart, and as discussed above, Abdul Quddus did not appear before the tribunal to establish that Kohinoor Begum, petitioner, was his daughter. Exhibit L is a self-serving affidavit sworn by the petitioner stating that she was the daughter of Abdul Quddus, whose name was wrongly recorded in various electoral rolls as Quddus Khatun, Quddus, etc. We fail to understand that when Abdul Quddus is still alive, as claimed by both petitioner and witness number 2, he himself could have sworn an affidavit clarifying the discrepancy in his name. But no such affidavit was sworn by the concerned person. As noticed above, Abdul Quddus did not appear before the tribunal to say that Kohinoor Begum was his daughter. In such circumstances, attempt made by the petitioner to project herself as the daughter of Abdul Quddus, whose presence in India, according to the petitioner, could be traced to 1966 has failed. Petitioner has failed to discharge her burden under Section 9 of the Foreigners Act 1946 to prove that she was not a foreigner but a citizen of India by adducing admissible, cogent, and reliable evidence. Therefore, we do not find any merit in the writ petition to warrant interference. which is accordingly dismissed. Interim order passed earlier stands vacated. Registry to send down the LCR and inform the concerned foreigners tribunal, deputy commissioner and superintendent of police border for necessary follow-up steps. A copy of this order may also be furnished to Learned Standing Council Election Commission of India and State Coordinator NRC.
So, yes. Page number 50. Yes, madam. Please read order 47. Mr. Mahmood, you text it, you will be allowed to give written argument. No, let her, you don't have to trouble your throat. Read order 47. It is marked here.
Order 47, Rule 1. Application for review of judgment. Any person considering himself aggrieved, A, by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. B, by a decree or order from which no appeal is allowed, or by a decision on a reference from a court of small
So
court.
review can be filed under this consideration. Now the grounds of review it is there. Just read. Read. And
who, from the discovery of new and important matter or evidence,
this is one. From the discovery of new and important matter or evidence. Read.
after the exercise of due diligence was not within his knowledge or
This
could not
is, yes, please proceed.
or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error
This is
apparent.
one that who from the discovery that new and important matter of evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order was made, or read the number 2.
Or on account of some mistake or error apparent on the face of the record.
This
Or-
is number 2 and 3.
Number
Or
2,
for
Appa-
any other, please proceed.
or for any other sufficient reason, desires to obtain a review of the decree passed or
Okay.
order made.
So these are the 3 grounds for review. First is discovery of new or important matter or evidence which after due diligence was not within his knowledge. So that was required to be placed before the order was passed. Number 2, error apparent on the face of the record. And third, for any other sufficient reason. These are the 3 grounds of the review. You have also read the grounds
Yes, Lordship.
for review. Now, this court earlier found that the proceeding failed to prove her linkage with her father before the trial. It is the duty of the proceeding as required under section 9 of the Foreigners Act to prove his or her linkage. That evidence is very much important, and it is only the proceeding have to say. Right. Now, the tribunal also found, which has also been found by the coordinate bench of this court, that proceeding do have exhibited, but there was no proof before the tribunal to show her linkage with her father Abdul Quddus. Right. A certificate was exhibited, given by the concerned panchayat, but that document was neither proved.
Yes, Lordship.
Contents of the documents was neither proved, nor the person who issued the certificate adduced any evidence to prove that document. So since the proceedee as required under section 9 of the Foreigners Act failed to establish her linkage, her proof, because section 9 of the Foreigners Act is very clear. Notwithstanding the Evidence Act, it is the duty of the proceedee to prove, establish her case that he or she is the Indian citizen. But since it was not proved, that documents were not proved in accordance with law, so the decision of the tribunal was upheld by the coordinate bench of the. You have read the grounds for review,
Yes, sir.
right? There are 3 grounds. Unless those 3 grounds are there, by way of filing a review petition,
Exactly.
we cannot rehear the matter, the grounds that you have already taken in the writ petition,
Yes, Lordship.
because this is not an appeal,
Yes, Lordship.
right? So, in your written argument
Yes, Lordship.
to be submitted by you on Friday, you have to explain whether the grounds of review that you have taken is within the 3 grounds as prescribed under order 46. Number
Yes,
1.
Lordship.
In guise of review, we cannot prefer an appeal.
Yes, sir.
So unless those 3 grounds are there, you cannot establish. The review will not sustain. A self-disclosed evidence is not a piece of evidence. That's the law laid down by the apex court, and which has been followed by this High Court on many occasions, not only in this case, in other civil matters. Right? So that is why, though an affidavit has been filed by the proceeding saying that Mr. A, Mr. B, Mr. C, all the discrepancies in the name, but it is only Mr. A which is my father. But names have been wrongly recorded as B, C, D, M.
Yes,
Whatever.
Lordship.
So these are the grounds.
Yes, Lordship.
After reading the grounds set forth by the review petitioner in this review petition and the order passed earlier by our coordinator, we have to see whether these are the genuine grounds for review or not, as been specified now. Okay. Now let us hear the other side. Yes, Mr. Pine, you will appear? Or Mr. Sharma?
May I plead, my lord?
Just give us the issues
Yes.
which are
Just, yes,
to counter the review.
yes,
petition.
yes. My lord, only, first of all, the issue of delay, my lord. The,
That will be taken care of.
Yes.
There are 16, we'll see to that.
my lord, put it, my lord, para 16, my submission is, it is not a, my lord, reasonable ground.
Hmm.
It is not a, my lord, reasonable explanation
Hmm.
for delay in lasses.
Of course, we have to here, as you know, there was a judgment, there is an order of the apex court
Yes,
during the COVID period that limitation will not run.
yes.
So
my lord,
that period will minus it
that period may your lordship may
go.
consider, but apart from that,
because it's an order of 2017.
yes, the order was passed on 24/1/2018, exactly 4 years after this writ petition is.
So that
review has-
period will be taken care of.
And for that, your lordship may kindly, I just point out the of a judgment of this honorable court, my lord, 2011 to GLR 510. 2011,
What is the proposition here?
there my lord, review the limitation, period of limitation, and the, my lord, the explanation has to be, my lord, inordinate delay and application of review, my lord.
Hmm.
That everything is discussed here, everything, my lord, the earlier judgment of this honorable court, that, my lord, the review under 226 jurisdiction review, my lord,
Mr. Payan, you give us
limitation.
the citation again.
my lord, 2011
11 to GLR
to GLR 510.
510.
Before going to that, that is a point, my lord. I would like to, my lord, point out the limitation at 124. Article 124 of the Limitation Act, my lord. There it is clearly said, my lord. Article says, my lord, Article 124 of Limitation Act, for review or judgment by a court other than Supreme Court, it is the 30 days period of limitation. Other than Supreme Court, it is 30 days. My lord, there is no specification that there is no any explanation. Only this is clearly given for a review or judgment by a court other than Supreme Court, it is 30 days. So it is against the High Court's judgment. So it is 30 days. That is 124. And this judgment has clearly says under which conditions, my lord, the delay can be condoned and which it cannot be. My lord. Then, my lord, with regard to limitation, that will do, my lord, as per my submission is that the para 16 of the review petition is not enough for condoning the delay, my lord. The explanation given in para 16 of the review petition is not enough to explain the delay because it is 4 years. Though it has been wrongly mentioned as 4 months, it should be 4 years.
Okay.
Now, the main point is, my lord, what is the ground of review? From the reading of entire, my lord, the grounds
Yes, madam, please take your seat. Take your
cited by, my lord, cited in the review petition, your lordship will find the
Yes.
ground number A, my lord. Ground number A, there it is said, my lord, the court that honorable court in order that it so and so passed in connected to petition number so and so, read court would not interfere with the findings of the fact unless it is case of violation of principle of natural justice. That is the basic point, my lord. Under statutory jurisdiction, this court is not going to entertain other than, my lord, if it is not, there is no violation of any principle of natural justice. So this point is correct. And, my lord, petitioner, the review petitioner could not, my lord, bring any materials
See,
to
in this
show
case, there was no violation of method.
no
This
violation.
was issued,
Yes,
she received and submitted her.
written statements.
So the question
She
of
has been given
violation of
enough
natural
opportunity
justice
for
is not
evidence.
there.
My lord. Yes,
Now
no
come to the
violation.
next point.
Next, my lord, the next point B in review.
Hmm.
The review petition is, my lord, B point here that it is said. Thus, may I read the first point, my lord? For that the view of this honorable court expressed through order dated so and so passed in connection with review petition number so and so, the documents exhibited by review petition, which the honorable court has held to be not proved by review petitioner in accordance with law is also jeopardized the review petition. This said view, my lord, this is a view of the court. Their view is that their submission is that the view is not correct. The view is not correct. It is not the purview of review, my lord. There may be 2-3 views, my lord. Whatever views taken by the court, that cannot be silenced in the review jurisdiction. It can be silenced in the higher forum. We have no objection at that. But in review, the view cannot be changed, my lord. View cannot be silenced. The view is hers towards the review petitioner. It's the view of the petitioner that the view taken by the High Court in the earlier judge, my lord, by the earlier, my lord, the coordinate bench is hers to the petitioner. That cannot be a ground of review, my
So
lord.
according to you,
This is the difference of view, my lord. Difference of view by the review petitioner and the, my lord, the
the
honorable court.
view expressed by the coordinate bench is not correct,
Not correct?
then it will be a case of appeal
Yes, my lord.
and shall not come under the review jurisdiction.
Review jurisdiction.
Okay, then third,
Third, my lord, for the honorable, they have taken a, my lord, the C, the for that honorable court also ordered that it so and so given negative emphasis on the variation of the names of father of the petitioner in electoral rule so and so. But doing so, honorable court did not appreciate the facts in both the electoral rule and, in fact, my lord, this honorable court under 226 certiorari jurisdiction may not, my lord, go through the evidence or reappreciate the evidence of which is appreciated already by the tribunal. This honorable court is to look whether the tribunal is correct or not. If tribunal has committed any error, my lord, then only the tribunal, this high court may interfere. So for the, this has been clearly discussed. The 66-70 voter list has been discussed, my lord, by this honorable court in the judgment.
So according to you, court is under, while exercising
Yes.
jurisdiction under certiorari, not required to analyze the evidence.
Evidence of the evidence what is available in the record. The court is to see only whether the tribunal has committed any error
In deciding the matter.
deciding it, or it has not taken, given the enough opportunity, my lord. Then D, my lord, they have said that this honorable court in order that it so and so hold a view. This again, my lord, it is the same difference of view. It is the, again this point, hold a view that the review petitioner failed to prove the linkage with so and so, proving the certificate issued by the Kokila, issued by the Kokila Gaon
Your
Panchayat.
answer is similar to the ground. B.
Similar, yes, my lord.
Okay.
Further, my lord, it is said the evidence that fact need not be proved. Authority that as the father's name has been reflected in the, my lord, it is now they are taking this point that as the father name is reflected in the notice and the, my lord, the inquiry report, the father's, it is a proven fact. For that, my lord, as this honorable court has already settled that it is not a, my lord, the investigation or the notice. If in the investigation and the notice,
That is in WPC number.
I'll
That we
provide
have
it, my lord.
given 2 days back.
Yes,
last week.
yes, it is there, my lord.
Give us the
I'll submit.
WPC. Because in one of the case that the
Yes, yes.
petitioner claimed that during the investigation, his name, father's name was shown as such.
Notice with the different-
So itself indicates that he is the
Yes,
son.
I'll
so-
provide that, my lord. This is a settled position of law. So settled position of law, it cannot be, my lord, reviewed. And further, it is the view of the my lord, proceeding that the court's view is not correct. It cannot be the ground of review. I'm not going to the, my lord, even if we do not go to the, my lord, the merits of the case also. Then, my lord, for the court below, the next view is that the past in connected with so and so discarded the affidavit submitted by review petitioner. Exhibit ground E, my lord. Their thing is that the affidavit was not considered by this honorable court, whereby they explained their, my lord, the variance
Self-shown
in the
affidavit.
name.
The law laid down by the
Yes,
apex court,
this
which has
is-
been
this is-
followed by our high court.
Yes, my lord, this
This
is
law
followed
laid
by
down
the,
apex court. The
this
apex
is
court
settled
does-
position of law.
That's in a civil procedure matter.
Yes, my
The
lord.
court have laid down, the apex court has laid down.
This is
that.
not an evidence as per the evidence act, my
That
lord. This-
cannot be considered.
Yes,
Self-
those are settled position of law. Then, my lord, for the honorable court have reviewed it, it is against the view of the, my lord, ground F. For the dishonorable court, one hand had a view that the petitioner was born in 1983. There was no view, my lord. It is their projected case. The petitioner was born in 1983. So, assuming that, my lord, dishonorable court passed in order. 83 was assuming that, and because they have given the, my lord, it is their projected case that the petitioner was born in 1983 and reveals from the aspect that she was born in village so and so. It is so. Then the review petitioner is an Indian national by birth, my lord. It is their case. They has to prove it by bringing some evidence that yes, I was born in India in 1983. There is no evidence to the effect. That has been, it is their projected case. The court has assumed that even though he was born in 1983, then also, my lord, there are some discrepancies for which the court rejected. This is discussed in the judgment. Only their cases that it was court has taken a view that the petitioner was born in 1983. This cannot be a ground of review, my lord. Then he said the next ground is that for the honorable court did not consider the public documents exhibited in support of the nationality, believing so and so, and brother of namely Ghulam Mustafa DW2, though name or SIM, the clearly established linkage. There is no link. Well, that is clearly discussed with regard to DW2. The judgment has clearly discussed why it is discarded and
Discarded
documents.
because the petitioner did not, in her written statement, did not state anything regarding her siblings,
Yes, my lord. That
nor
is,
the existence of DW2.
yes,
What the petitioner, before the tribunal, in her reply to the so cause, clearly stated that her parents are alive. But accepting that, there is no statement in her written statement that she has these number of brothers or these number of sisters. And the coordinate bench earlier he found that there is no mention of DW in her retention.
Yes, my lord, these are the facts, my lord, but this has, all these aspects has been discussed in the earlier judgment. So it cannot be a ground. These
It will not
grounds
come
were
under-
taken in the earlier writ petition.
It will not come under the three grounds as
Yes,
specified
yes,
in
yes,
the
yes,
Order
specified.
47.
These grounds were taken in the writ petition. And these were argued at that time. And same argument raising again and again, that will not come under purview of the review jurisdiction, my lord. But there is no rebuttal against the evidence of the petitioner as well as the brother on vital point. This is section 9 of the, my lord. The Foreigners Act has clearly said it is their duty to prove the case, and this is settled position that even though they have to bring the cogent, reliable, and admissible evidence and prove it, only after proving, if necessary, the rebuttal will come. My lord. Rebuttal is not a mandatory thing. My lord. It is rebuttal will be necessary if they establish the case by bringing cogent, reliable, and my lord, admissible evidence. That is settled position of law. These are certain positions of law. This cannot be ground of review, my lord.
Let us see what he has said on 2013 1 GLP.
Yes,
That also will.
that is, my lord, Muslim Mandal,
No, Abdul Khalik.
Abdul. 2019, 13 1 GLT.
I think this, no, that is Abdul Khalik case, I think probably again
Yes,
clarified.
that has been, my lord, that has later been, my lord, clarified by this
another
honorable court.
division bench.
Yes. Even the Muslim later on also numbers of judgments where, my lord, this is settled. The rebuttal is only necessary. Even in fact, my lord, para 26 of the Sobananda Sunal itself says the petitioner, the proceeding has to bring evidence on particularly date of birth, place of birth of the petitioner, their citizenship, the father's citizenship, and their parents and grandfathership necessary, and bring evidence to that effect. And the state may rebut only if they establish the fact first. Then only rebuttal will come. If necessary, the state will give the rebuttal. If necessary, word is specific in India. So first of all, it is their duty to prove under section 9 of the Foreigners Act that he is not a foreigner. By bringing, my lord, once again, I'm saying that because this by bringing cogent, reliable, and admissible evidence. The
No, Mr. Payang, that Abdul Khalik's judgment
yes,
was
but
later clarified. Do you have that judgment with you? Where only when the proceeding could provide such admissible, reliable,
Yes.
and cogent evidence
I'll provide the
to
judgment.
be accepted by the tribunal. Thereafter, the burden shifts to the other
Yes.
side.
First of all, I'm coming one by one, my lord. Your lordship may kindly see this is WPC number 3917 of 2016.
What is the issue there?
Dear my lord, the name of the proceeding. If the father's name of the proceeding appears in the notice or the my lord inquiry report,
3919.
yes, 3917, my lord.
Hmm.
3917 of 2016.
Sharma, लिखी लो वो print out लगेगा. Yes. Proposition there.
Date of judgment also.
My lord, your lord, the date of judgment is 13/02/2018, my lord.
1302.
2018. My lord, there the proposition was Parat 14, my lord, it says. Before proceeding further, we may deal with the argument of the learned counsel by the petitioner that mentioning of the petitioner as daughter of Akbar Ali Bepari in the notice issued by the tribunal itself was a proof of fact of such relationship. So here is the case, same argument is there. We are afraid we can accept such an untenable argument advanced on behalf of the petitioner. Para 14, madam. Making of a notice to person mentioning therein.
Yes.
Yes, my lord, para 14, my lord. May I read against, my lord? Before proceeding further, we may deal with the argument of the learned counsel for the petitioner that mentioning of petitioner as daughter of Akbar Ali Bepari in the notice issued by the tribunal itself was a proof of fact of such relationship. Same is the case here, my lord. We are afraid we can accept such an untenable argument advanced on behalf of the petitioner. Marking of notice to a person mentioning therein the person to be the son or daughter of some other person cannot be construed as the proof of the fact that noticee is the son or daughter of that person. This is mentioned in the notice only for the purpose of identification of the notice and the service of notice. Certainly, it cannot be taken as a proof of notice being the son of daughter or daughter of the person. This information cannot be obtained from the noticee herself. This information can be obtained from the noticee herself or from some other documents or source, but it is no proof of the fact. This is particularly so in the context of Section 9 of the Foreigners Act 1946, which has been explained in detail by the Supreme Court as above. Even then, we may, that is the point, Mal. Even then, we may briefly examine the relevant provisions of the Indian Evidence Act 1872. Then here describe, Malak, Section 3 of the Evidence Act in the interpretation clause, fact has been defined to mean and include anything that of things or relation of things capable of being perceived by sense, any mental condition of which any person is conscious. Then a fact is said to be relevant to the another when the fact is connected with the other in any of the way referred to this act in the act relating to the relevancy of the facts. The expression facts in issue has been defined to mean and include any fact from which either by itself or in connection with the other facts, the exercise, the existence, non-existence, nature of extent of any right, liability or disability asserted or denied in any suit of proceeding necessarily follow. Under Section 3 of the Evidence Act, evidence means and includes oral evidence and documentary evidence. All statements which the court permits or requires to make before by witness in relation to matters of the fact under inquiry would come within the ambit of oral evidence. On the other hand, all documents, including electronic records produced by the inspection for the inspection of the court are documentary evidence. The word proof has a different connotation. In the context of the Evidence Act, a fact is said to be proved when, after considering the matters before it, court either believe it to exist or considers its existence so probable that a prudent man ought, under the circumstance of the particular case, to act upon the supposition of that existence. A fact is said to be disproved when, after considering the matters before it, court either believe that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstance of the particular case, to act upon the supposition that it does not exist. A fact is said to be not proved when it is neither proved nor disproved. So details discussion, my lord, what is fact and what is need to be proved, that has been given here. And it is clearly said, mentioning the father's name in the notice will not, my lord, say that he is the father of that person. It is for the limited purpose, my lord. Then on the same proposition, my lord, another judgment of this honorable court, 252. Then, my lord, this is on self-swearing affidavit. This honorable court in, my lord, WPC number 2751/2019, my lord. 2751 of 2019.
Whether the judgment of the apex. court is
Yes, it
recorded
is cited here in this
in-
case,
That
my
is
lord.
what is more important.
It was on judgment dated 4/5/2019, my lord. 2751 of 2019 WPC. Disposed of on 4/5/2019.
It's a self-shown affidavit.
Yes.
That's the, what is the proposition, being the law laid down by the apex court, you go to that.
Yes, my lord. Para 12, it is discussed. Affidavit are not included within the purview of definition of evidence. It is held in Ambukon Nurkhan Pathan versus State of Maharashtra and others. 2013 4 SCC, my lord, 465. 2013 4 SCC 465.
Hmm.
That the filing of an affidavit of one's own statement in one's own favor cannot be regarded as a sufficient evidence for any court or tribunal on the basis of which it can come to a conclusion as regard a particular fact situation. So this is the proposition laid by the Supreme Court,
That's right.
and has been accepted by the Senate Court in the case. And with regard to, my lord, the rebuttal evidence. First of all, your lordship may kindly see the para 26 of the Sobanada Supreme.
Hmm.
Para 26, my lord.
2005,
Yes, my lord. 2005,
1 SCC,
1 SCC, 665. Para 26, it is said, my lord. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of a particular country. In order to establish one's citizenship, normally he may require to give evidence of, number one, his date,
265 page,
page, my lord,
665.
665, my lord. 5 SCC, my lord, 2000,
2001, 5 SCC,
no, 2005, 5 SCC, my lord.
2005, 1 SCC,
5 SCC, my lord. 2005, 5 SCC, my lord.
now
665.
1 SCC or 5 SCC?
5 SCC, my lord.
Sometimes they also play.
Mr. Payal, you have a printout copy.
No, it is there.
Yes.
What is it? 2005, volume
5
5.
SCC, 5 SCC, my lord. 5, volume 5, my lord.
5, volume 5, SCC
Yes, my lord.
665.
665.
Okay.
Doesn't he?
Para 26.
We have to remember 5, 5, and 5 last.
Yes.
5 SCC. Para 26, my lord. Because this is important for the purpose, my lord. There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be citizen of a particular country. This is not only for India, my lord. This is for a particular country. In order to establish one's citizenship, normally he may be required to give evidence of, my lord, it is very important, his date of birth, 2, place of birth, 3, name of his parents, 4, the place of birth and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A1D of the Citizenship Act. Then, my lord, all these facts would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. after he has given evidence on these points, the state authority can verify the facts and can then lead evidence in rebuttal if necessary. My lord, this is the point where it is said, my lord, that all these facts, the aforesaid facts, would necessarily be within the personal knowledge of the person concerned and not the authority of the state or the state. After he has given evidence on these points, the state authority can verify the facts and can then lead evidence in rebuttal if necessary. So they have to establish first. Then only if necessary, the state will my lord rebut. The same point, my lord, in the division bench by the Honorable Court has clearly said, and this is, my lord, 2000 WPC 2641 of 2017. of 2017, my lord. The state versus Ohapali. They are in para 16, my lord. It is clearly said, para 16.
Or this is state versus
Ohapali, my lord.
Ohabali, yes, that's
Yes,
right.
OACB, Ohapali. 2641 of 2017, disposed upon 29/5/2018, my lord.
That's right.
Para 16, my lord. There, under section 9 of the Foreigners Act 1946, burden is on the proceeding
No,
to
you are reading para 16.
para 16, my lord,
Huh.
from the middle part. In fact,
Huh.
your lordship may kindly see
Yes,
the
after that decision of the Muslim.
decision of the Muslim Mandal. 2013 1 GLT 809. Then under section 9 of the Foreigners Act 1946, burden is on the proceeding to prove that she is not a foreigner, but a citizen of India, and this burden never shifts. The burden has to be discharged by the proceeding by adducing evidence which are admissible, which must be proved, and which must have relevance to the fact in issue. By mere filing of documents without examining its admissibility and without documents being proved or without examining its relevance, it cannot be said to that the proceeding has discharged his burden. Question of rebuttal evidence by the state will arise only if the proceeding adduces evidence which are admissible, proof, and which have relevance. So rebuttal will come only then on, Mala. If the proceeding bring evidence and which are admissible and which are proof and which are relevant. Then only, Mala, the question of rebuttal will come. If they fail to bring admissible evidence, and if they fail to prove that admissible evidence, and if this evidence are not relevant, then there is no question of rebuttal by the Mala state.
Okay.
So, and further, my lord, my submission is that all these grounds are, even though these are minor grounds for challenging before the apex court, these are not grounds for review. Review says, my lord, only 3 grounds. Where is the error apparent in the face of the record? There is no error apparent shown by the the review petitioner. There is no discovery, new discovery in the facts. Even after due diligence, they fail to discover the facts, my lord, that is not brought into the record in the review petition. And there is no other reason. These all are ground of review of appeal, even though I accept my
Okay, fine. This is one. Then that Akasali, that decision of the, this was discussed later on, clarified.
That is in this case itself, my lord, in 2013 1 GLT 1, 941.
No. That Abdul Khalid case later on. Justice Kotoki and Justice Goswami at para 9 had said something, right? That because the two other witnesses named that such and such is the daughter and son of such and such. So that is whatever, that is has been clarified later on.
Yes,
That has been.
but now I don't have the judgment, my lord. as of now.
There is a judgment, you give it us by
Yes,
tomorrow.
yes, ma'am. And further, my lord, my contention is that these are not grounds of review. These are grounds of
No, you
review.
have said-
writ petition.
All the grounds that we have marked,
Yes, ma'am.
right?
Yes,
But what is, you can took down, madam, that decision of the coordinate bench passed earlier, which is under review now. The court found very specifically that the proceedee failed to establish her linkage with her father. If you come to page number 21, that is judgment. Come to page number 24. Now, the third paragraph.
Yes.
We are reading it for you. Petitioner is claiming her Indian citizen through Abdul Quddus, whom she claimed to be her father. But in Exhibit F, voter list of 1966, name which appears as Quddus, son of Akash Mia, aged 36 years. And in the voter list of 1970, name of which appears as Quddus Khatun, son of Akash Mia, aged 40 years. Now, the ground taken by you is that house number is same, 66 and 1970 voter list, that has not been considered. Now, the next line. Even if we ignore the discrepancy in the name, what is Abdul Quddus or Quddus Khatun. So this takes care of that
this,
the house numbers is similar, age is similar, only the names are, there is discrepancy, the name should have been considered. That is not the court considered. What the court considers, even if ignoring the discrepancy, what the court found was that what was required of the petitioner was to prove her linkage as daughter of Abdul Quddus. This was not proved before the tribunal. Exhibit A is a certificate dated 17/11/2015, issued by the President and Secretary of Kokila Gaon Panchayat, District Bongaigaon, certifying that the petitioner was the daughter of Abdul Quddus. The next, this certificate would have no significance because the author of the certificate did not testify before the tribunal to not only prove the contents of the said certificate, but also the truthfulness thereof. In the absence of such deposition, no reliance can be placed on Exhibit A. That apart, and as discussed above, Abdul Quddus did not appear before the tribunal to establish that Kohinoor Begum, the petitioner, was his daughter, because in the written statement said that parents are alive.
Yes, sir.
Indeed, finding. The secondly, even in the Rubzan Begum case, if you read, there are two parts. The law laid down by the apex court, again it is true. If there is something in the document, contents may be true, but the person who have issued that certificate, the truthfulness of the certificate has to be proved by the person concerned who issued that certificate or the authority concerned. Here, Exhibit A, that the certificate issued by the Gaon Panchayat has not been proved.
Yes, sir.
To prove the linkage between the petitioner and her claimed father. Right? Okay. Now that next para is Exhibit L, talking about the self-serving affidavit. You have just heard how the Honorable Apex Court in 2013 for SSC 465 have clarified that self-sworn affidavit is not cannot be considered as a piece of evidence. Right? Anyway, anything else, Mr. Pai?
My lord, I have relied yesterday, my lord, two judgment. One is
2013, that one.
yes, 13/8 SCC 320 and 2022 SCC online 1034.
2013,
8 SCC 320.
that grounds of review,
Yes,
on which conditions 20.1 and
yes,
20.2.
yes, ma'am.
Okay,
Then, my lord,
and one is in the SSC online, that is?
2022, my lord, SCC online SC 1034. From para 16 onwards, my lord, 6 in that case.
That is also where the earlier judgment of 2013 was considered. And
Yes,
passed.
everything is considered, my lord, and said, my lord.
You note down these judgments, madam. You have to consider and give your reply
Yes, sir.
in your written argument.
One thing, my lord, one judgment of the Honorable Apex Court I would like to point out for the purpose of this case, my lord. The 1997 9 SCC 736.
1997, 7 SCC,
9 SCC,
9 SCC.
736.
Yes, what is the proposition?
Here, my lord, the filing of review petition without any ground by sending lawyers is not, my lord, deficitated by the Honorable Apex Court.
No, here, that is not the issue. It's true that there are, in other cases, we found that the review that there was change of lawyers. That
Here also-
set of lawyers did not argue. It was, in fact, it happened earlier also. In fact, in one of the case for review, recently in one case,
Yes.
Mr. Ken Chaudhary have placed that. Changing of the lawyers is not the issue here. Oh, Mr. P.N. Goswami took that, not Mr. Ken Chaudhary. And they got the eviction from forest levy. Yes, so what do you want to show from this judgment?
My lord, may kindly see para 2 and 3 of the judgment, it is clearly said, my lord. Once the petition for review is dismissed, no application for clarification should be filed, much less with the scenes of advocate on record. The practice of sending the advocates and filing repeated petitions should be depreciated.
No, how it's related to this case? How it is related to this case? Maybe somebody was there in the read petition. Now another set of counsels have appeared in the review petition, but they have not taken that ground. This is a case where once the review petition was filed, and thereafter, after the dismissal of the review, probably another application was filed by a different set of lawyers.
Yes, my lord.
In that background, the Honorable Apex Court has passed that order.
Here, the fact was, my lord, it is a small judgment, my lord, may read the entire judgment, that a new practice unbecoming and not worthy of conductive to the profession is coping up. Mr. So-and-so advocate record has filed wakalat number for the petitioner respondent when the special leave petition was filed. After matter was disposed of, Mr. So-and-so had filed a petition for review. That was also dismissed by this court on so-and-so. Yet another advocate, Mr. So-and-so, has now been engaged to file a present application, state as application for clarification. There, my lord, the review petition was also dismissed. Then again, clarification was filed by some other. For that reason, it was.
In that context,
In that context, it was.
this has nothing to do with.
This may not be taken. So that is
Anything
all.
else?
That's all, my lord. My humble submission is that, my lord, there is no ground of review.
You have shown the grounds
Yes.
which have been taken by
Yes.
the petitioner.
Yes.
Petition are not terrible under the
Yes,
jurisdiction review.
review. So it may be dismissed at this.
For you, it is easy to submit to dismiss, but no, for us, it is different, right?
Yes.
Yes, Mr. Mahmood, you submit your written argument. You need not argue by, you can understand your reply.
But before Friday, it took several a lot.
No, brother will not be available thereafter.
That's actually. May I submit some answers today itself?
No, you, because we do not want you to,
I
Force
understand that.
you give your
When
written
and the
argument.
end,
It will be easier for also brother to go through it and to submit it. So brother will be having the last court on this Friday. So you submit it, give it to our bench assistant by Friday. We'll take care of it.
well,
Today is Tuesday. Submit it at 1:30, 2 o'clock on Friday. Mr. M.U. Mahmood, Learned Counsel. What's your good name, ma'am?
Deborah, Miss Deborah.
Assistant by Miss. For the review petition. Also heard Mr. Depai. And extend your consent to the court. There is the record. The review petitioner is allowed to submit or written argument as Mr. Mahmood, our learned counsel. Cannot make oral arguments because of his throat impact. Okay. Yes.
all right.
Hablo Lordship.
Why? 22nd March 2024. Hearing of access. On or before 3 p.m. You have given everything. You submit up to 3 p.m. Okay. এই যারা এখন provide you এখন তোরা রেডি করে দিব কিন্তু এখন ব্লাড লাইব্রেরি করে আর নহলে এখন এটা ফোনে আছে যদি হয়তো প্রিন্ট আউট করা Yes, next.
Yes, Lordship.
Yes, please.
Lordship, in this connection, I will file written argument. Lord.
First of all, tell us what is the order of the coordinate bench, on which date order was passed?
Page. Page 82.
Order was first of 5th of September 2018.
Lordship.
When did you prefer the review petition? 2022.
Lordship, I will mention in page 16, Lordship.
You have filed it on 15th of February.
Lordship.
So,
In page 15, Lordship, I mentioned
3.5 years.
clarification.
3.5 years. What is the ground? Which paragraph?
In paragraph 16, Lordship, page 15.
Where is the order of the Supreme Court? Which page?
In last page, Lordship, in page 92.
Take your seat, Mr. Suleiman. 2009. Okay. What are the grounds you have taken? Can you read the grounds? Page number 16.
16. For that Honorable High Court dismissed the petitioner above read petition being so and so, WP number person, merely on the tribal technical grounds without going into the merit of the case, and upheld the opinion and order dated 29/7/2016 of the Learned Foreigners Tribunal on Karimganj. The Honorable High Court, for the end of justice, ought to have ratified the opinion and order of the Learned Tribunal and remanded back to the tribunal to decide the matter fresh by giving one opportunity to the petitioner, considering the fact that the petitioner is poor lady and belongs to down-trodden part of the society as citizen of a person may not be taken away merely on technical ground, and hence the impugn order is bad in law and liable to be satisfied in court. B. For that, though the document of citizens were available with the petitioner, but her learned counsel did not produce the same properly at the time of hearing, and for which learned tribunal rejected the pleading made in the petition. The family members of the petitioner being illiterate and are also not fully aware of the legal proceedings. C. However, the petitioner exhibited the brutal list of 1966, 1970, and 1997, wherein her father's name is appeared and the brutal list of 1994 for herself. Apart from that, the petitioner exhibited the Gaupanchayat transfer certificate issued by the concerned secretary and duly countersigned by the circle officer from Krishnanagar Revenue Circle, Karimganj, as well as land sale deed of her father dated 1/3/1979 and marriage kabinnama to establish a linkage with father. But learned tribunal without considering the above mentioned documents came to a finding that the petitioner has failed to produce sufficient documents to establish a linkage, and opined that the petitioner entered into India illegally after 24th March 1971. D. For that, this honorable court, while dismissing the petition, held that there is no merit in this petition. Consequently, affirmed the older order of the learned tribunal that the petitioner is foreigner. But the petitioner annexed the brutal list of 1966, 1970, 1997 to establish the linkage of the petitioner with her parents. The petitioner annexed the brutal list of 1994 for herself, paternal house of her paternal house. The petitioner annexed the Gaupanchayat certificate and sub-certificate sale deed of her father dated 1/3/1997 and marriage kabinnama to the discharge of pardon under Section 9 of the Foreigners Act, thereby failed to apply the test of the provision of Section 6A of the Citizenship Act 1955. Hence, the impugn order is bad in law and liable to be satisfied in court.
Mr. Counsel, ground C and D seems to be similar. C and D seems to be similar, isn't it?
Yes.
Anyway, you read ground E again. Ground E.
Yes. Marriage similar.
Ground C, you have mentioned about 1966, 1797, Kabinnama, all that. Same thing again in ground D. Both are same. That is what I'm
I
saying.
think that copy pasted has been done.
Copy pasted. Okay, you read ground E.
For that, the default of the petitioner is in the above case on extraordinary situation as because the petitioner is illiterate and unaware about legal proceedings. This honorable court in a full bench judgment report in 2013 1 GLT FP 809 in paragraph 89 to 92 held that the learned tribunal has power in vacating the order under extraordinary circumstances. In this case, the learned tribunal failed to appreciate and apply his judicious mind.
What is this judgment? Muslim Mandal,
2013,
full bench.
2013, 1 GLT Muslim Mandal.
Full bench is Muslim Mandal, I think.
Yes.
Yes, yes, Muslim.
Muslim Mandal. F. For that, the inquiry conducted by the border police before referring the matter to the foreigners tribunal is totally blurred, and there was no iota evidence in the said inquiry which merits reference to the learned foreigners tribunal. The learned tribunal, without applying its own mind on the said inquiry report of the border police, mechanically issued the notice to the petitioner. G. For that, Honorable High Court and the learned tribunal failed to consider the petitioner is a poor lady and have lack of knowledge about legal proceedings may not be prejudiced into petitioner, adversely considering the matter related to the citizenship of person. Social lawsuit. G. H. For that, the Honorable Supreme Court in Sarvananda Sanwal 2 case reported as 2007 1 SCC 147 at para 55 held that adequate care should be taken to see that no genuine claiming citizen is thrown out from land. A person claiming citizenship in terms of Constitution of Citizenship Act entitled to all safeguards, both substantive and procedural, to show that she is a citizen of India. I. For that, considering the determination of any person's citizenship is more or less like determining the fate of a person's life. Therefore, taking away the citizenship of the petitioner as citizen of India on trivial ground,
Tantamount.
to violation of fundamental right as guaranteed under Article 21 of the Constitution of India. As such, the learned tribunal ought to have been more cautious and ought to have taken steps to verify the details of her antecedents, as it is evident that her other family members were never questioned by any authority, and their name all are along been listed in the voter lists and other relevant records. G. For that, petitioner being born in India is a citizen. Born in India is a citizen by birth as prescribed in Section 3(1) of the Citizenship Act 1955. Okay. For that, honorable court ought to have followed the principle of quia equi should not only be done but should manifestly be has been to be done. For that, considering the fact that the citizenship of a person impacts hugely on a person's life, and no genuine Indian citizen be harassed Therefore, there ought to have been substantial and enough material evidence before declaring a person illegal migrants and non-adherence to the same tantamount to violation of the constitutional and human rights of a person, hence required to be reviewed and modified.
What is the document that you have proved before the tribunal as well as brought before the notice of the honorable this court, the coordinate bench, that linkage between Safara Begum and her father Abdul Karim has been proved?
Lordship, page 37.
Page 37. What is it?
37.
37. Yes.
Abdul Karim, 36 or 37, 30,
No,
37.
no. How you have proved that you are the daughter of Abdul Karim? This is not Abdul Karim, this is Karim.
And Karim, that is Abdul Karim Lordship, in short form Ang, in Bengali type. In short form of Ang, especially this proceeding in going in Borakville Lordship. Abdul, in short, Ang.
Answer.
Like Sheikh also SK.
SK Lordship.
Sheikh also short form is SK.
Sometimes people have written Lordship.
36 is a voter list of 1994.
1994.
We have nothing to do with this. Now,
Safara Begum, father of Abdul Karim. Safara Begum is petitioner. Her father is Abdul Karim. In page 36, Lordship, kindly come. Abdul Karim, that is father. Rahima Bibi, mother. Rashid Ahmad, uncle. Not uncle or brother. Safara Begum, myself, Lordship. Jubera, sister, Rajia, sister, and Gulabjan, another.
this was exhibited as what? This voter list was exhibited what?
Exhibited in copy in 33, page 33 is exhibited.
As exhibit?
Exhibit number.
Exhibit 33, exhibit 5, laptop. Exhibit 5. Exhibit 5.
Okay.
The Panchayat certificate also there, Lordship. GP certificate.
Just a minute. When the order of the tribunal was passed?
Lordship, opinion is
29/7.
82 page.
29/7/16.
29/7/2016, right?
Lordship.
Mr. Suleiman,
Lordship.
2016.
16.
So at page 82, it is very clear. Now please come to page number 36. This voter list of 1994 was applied. Date of number of application is 1173. Date of issue is 01/08/2019.
Lordship, I annex the list in first I annex page 32, Lordship. I exhibited.
As what?
Lordship, as one.
Where is your written statement? Where is your?
It's written in 75, Lordship. Page 75.
We have mentioned about this.
Lordship.
What is not? Come to page number.
Page 88, paragraph 5,
Page,
88, paragraph 14, man.
no, para 11, page 77.
Page 7, that in the year 1994, Opi's name was enlisted first time when she was attained 21 years of her age in LA1 Ratabadi constituency SC, part so and so, name of section so and so, district so and so, in serial number 1081 house number and so on.
What is the finding of the tribunal with regard to this exhibit?
Page 88, paragraph 14.
No, that will go for the division bench order.
Yes,
Tribunal's finding.
Sir, concerning page 80, page 84, Lord. Page 84, on careful scrutiny of the above transpires that A, one, Karim accepted Abdul Karim. Scrutiny was within the kingdom.
paragraph 10, my lord. 84.
Para?
Page 84, paragraph 10, it is discussed. Exhibit 5, electoral roll of 1994. The name, my lord, it was a single person voter list. The present document was not before the tribunal. The,
It was procured later on.
yes, it was procured later on. This document was not before the tribunal.
That's true. That is the reason we're asking, because it itself indicates it was procured on 1st of August 2019.
Yes.
The order is of the tribunal of 2016.
Yes, this document was not before. The only document voter was the petitioner matter in that document. Exhibit 5, electoral law 1994, the name of the father of the Safra Begum is Abdul Karim, but it has not been made clear what was the name of father of Abdul Karim and why the name of Abdul Karim was not in the as elector did appear in the exhibit. So nobody was there except the petitioner in that voter list. More particularly, when in 1997, Abdul Karim was a elector. 97, the Abdul Karim.
Next page.
Yes. So this was procured later on.
Page 33 was exhibited before the tribunal.
Yes, Lord. Page 27, Gaon Panchayat Circular, Lordship, Exhibit C.
Did you prove,
No, Lord,
did you prove that document?
no, Lordship.
Then
In fact, all these have been discussed in the judgment matters of the Honorable Court. Details discussion.
what is the observation made at regard to that by the coordinate bench?
88.
Five,
Page 88, Madam. This was to read on the whole leaf from para 11, Madam. Exhibit 2 is the voter list of 1966. The sole voter was Ang Karim, son of Soinsho. Then exhibit 3 is the voter list of 1970, where the voter was Abdul Karim, son of Kutimia, is 34. Then exhibit 5 comes, Madam. 94 in respect of Ratabari constituency. Their sole voter was Safara Begum, daughter of Abdul Karim, aged about 21. She was resident of village Balirbon. Exhibit 9 is the certified copy of extract of the voter list of 1997 in respect of Ratabari Assembly. The true voters were Abdul Karim and son of Putti Mia, aged about 21. Rohima Bibi, wife of Ang Karim of 40 years. They are resident of Rangpur under Ratabari police station. Now, my lord, there are 16. Till this point of time, there was no disclosure by the petitioner either in the written statement or in the evidence in shape about the identity of her mother. From exhibit 9, one can infer that Rahima Bibi, being the wife of Ang Karim, whom the petitioner claimed to be her father, could be her mother, but she is conspicuous by her absence all throughout, only to appear in exhibit 9. That is, exhibit 9 is 1997 voter list. As voter at the age of 40 years. Later part in the written statement, petitioner stated that in 1975, when she was 2-3 years old, father shifted from village Raut Gram to village Rangapur along with her family and permanently resided there. Petitioner also stated that she has got married to Islamuddin on 18/7/1995. Therefore, prior to 18/7/95, she was residing with her parents at Rangapur. But exhibit 5 says that she was a resident of Balirban. That apart, both the Abdul Karim and Rohima Bibi were conspicuous by their absence in exhibit 5, which is the voter of 1994. At least in exhibit 5, that is in the year 1994, all three names, Abdul Karim, Rohima Bibi, and Safara Begum, ought to have been voted together, but it is not so. These are crucial omission, raising serious doubt, question marks about the veracity of the petitioner's claim. This has been discussed today clearly. So 66, 70, 75, 94, 97, all these voters lists were considered. And after considering whether this honorable court has passed this order judgment. Then exhibit 9, para 17, it will be clear again.
where is the voter list of 1970?
Page 43, madam. This is appropriate, yes. Page 43.
So after 70, it is 97. In between, no voter list.
1977 was there probably, but exhibit. Ninety, 94, 75 was there.
No, there is which,
Exhibit 9. Exhibit 3 is the voter list of 1970, then 94, my lord. Exhibit 5, 94. Then exhibit 9, it is 1997.
so after 70, it is 94, 24
Yes.
years later.
94, my lord.
Ninety-seven also lordship, page 48.
97.
97.
94 and 97.
No,
97.
after
Ex-
70, 24 years later, you have given your voter list.
Exhibit 9.
Whether the Ankarim continued to be there in after continuously or not.
It was continuously lordship. It was continuously.
Paragraph 17 of the judgment, my lord, it is clearly stated why it cannot. Because in 19, the Honorable Court has said, my lord, as per the voter list of 1997, this Abdul Karim, present Abdul Karim is 50 years. So his date of birth will be sometime in 1947. So he would be only 19 years in 1966. But the 1966 voter list, Ankarim is 30 years. If the position would have been 19 years in 1966, would not have been eligible to cast vote. But exhibit to 66 voter list, Ankarim was 30 years. So it's a crucial contradiction, my lord. That is the word used by the court, my lord. The petitioner says that she was born in 1973. If that be so, her mother's presence should have been there in 1972. But it's there is neither any pleading nor any documents in this regard. In the voter list of 1970, there is no presence of mother. Nothing has been stated either in the written statement or in the evidence to when the parents of the petitioner got married. And this ground of my lord Kabil Nama being not considered is totally considered at para 20 mile.
Okay.
Sale deed was not considered, that is considered it based para 19 mile.
So we have seen.
Kabil Nama at para 20 it is considered.
That's not true.
Yes, that is
That
not
has
true.
nothing. No issue.
So everything is yes.
Any material to show the existence of Ankarim from 1970, after 1970 till 94,
After 1970.
after 1970 to 1992.
So exhibit 4, page 62, sale deed lordship.
Sale deed is considered.
That will not help you.
My
Who
father-
proved this document? Who proved this document? Anyone proved?
Not proof lordship. So it is registered document lordship. My father purchased that plot.
এই দুটা কালি লগাই দিয়া সিঙ্গল বেঞ্চৰ যিকেইটা মেটাৰ আছে সেইকেইটা কালি Mr. Das, we will take up the single matter matters tomorrow. Well, okay. There will be another matter, review matter. So
Oh, yes, sir.
finish this and the other review matter, thereafter we'll take the single. ठीक है sir? This will take up tomorrow, half done. We'll hear him tomorrow.
Lordship will decide, Lordship. নালাগে এটা কোনো প্রবলেম নাই কিন্তু আমরা এই না নালাগে আপনার তো হয়ে গেছে অলরেডি না লাগে না লাগে কম শর্ট করে
When did your father expire? While he was 2, 3 years old. What you have stated in your written statement or in evidence, what you have stated? No, no, no. You shifted from one village to the other while you were young.
Yes, yes, Lordship. I shifted. It is Radgram to Rangpur.
Yes, but it is not your case. Let us assume for the time being that in the voter list of 1994, your name appeared along with your projected father.
Lordship.
But this is not your case before the tribunal, before the court earlier, that nor in this review petition, that name of your father, projected father, figured in the voter list after 1970, in between 1970 and 1994. There is nothing. We'll hear it tomorrow. Click for it. Click for it. আর ওই কিতাবখন রেডি করবো ক্লিয়ার করে ক্লিয়ার পঢ়িব পাৰিব কিন্তু স্পষ্ট নাই আৰু কেইখনমান পেজ কৰিছে ফাইলত পানী এই এতিয়া এখন তাতে লৈ যাব এই ফাইলবোৰত পানী